Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Hello, everyone. Welcome to another edition of the Empowering Plans Podcast, a special Thanksgiving edition. I'm your host for today, Brady Bizarro, and joining me is one of our finest consulting attorneys, Andrew Silverio. Say hello, Andrew.
Hello.
Awesome. Well, today we have kind of a different topic to cover, one that I don't think gets enough coverage, frankly, from all the things happening lately with COVID-19 and the No Surprises Act. The Supreme Court's making a number of waves lately by taking some cases, as they typically do in the fall, that they usually decide later next year in the spring. But one of them, I think, is one that could have significant impact in our industry, and that has to do with dialysis carve-outs and the Medicare Secondary Payer Act and the interactions there. A lot of our clients utilize dialysis carve-outs and have a stake in sort of how this case will come down. But before we get into why this case was taken by the Supreme Court and what we think may happen, I think it's helpful first to take a step back and provide some background about, why these issues are even happening now, why they're relevant, right? So, Andrew, why don't you give us a bit of a background on what you've seen with, what our clients try to do to handle dialysis claims, why there's a concern about the Medicare Secondary Payer Act, and kind of we can go from there after we know sort of the history of this all.
Sure. Yeah, thanks, Brady. So, at a high level, the main reason that plans are very concerned about dialysis claims is that they're very expensive, right? This treatment goes on for months, it goes on for years, and those dollar amounts can really skyrocket well into the hundreds of thousands of dollars for a single patient. So, understandably, self-funded plans want to figure out some way to manage these costs. And dialysis carve-outs, which, that term means different things to different people. It's just a method of singling out these claims, dialysis claims, and treating them differently than other claims in one way or another. So it's a common and popular approach to try to manage some of the most troublesome claims under a self-funded plan. So for that same reason, because these dialysis claims are so very expensive, having end-stage renal disease, which is basically kidney failure that is not going to get better, that's the end-stage part of it, that's a basis for Medicare eligibility. We do kind of have universal health care, Medicare for all, as it relates to one condition, which is ESRD. So in that respect, that's sort of already in place. And because that alternate coverage is available, plans often see these claims as good opportunity for savings to carve them out and avoid that health expense, knowing that there's another potential source of coverage out there. That is why the biggest challenge with these dialysis carve-out programs is usually the Medicare Secondary Payer Act. The Secondary Payer Act is a set of laws designed to prevent health plans from shifting expenses onto Medicare, among other things. And they set different rules based on the reason that somebody is eligible for Medicare. So based on age versus based on disability versus based on having end-stage renal disease. And the ESRD provisions are the broadest and most limiting as far as the Secondary Payer Act is concerned. So that usually presents the major challenge for plans trying to implement dialysis carve-outs.
Right. And so what we've seen over time, right, Andrew, is basically a number of challenges to plan language and sort of tactics by plans, which in the eyes of dialysis providers, at least in their view, unfairly kind of penalizes them because they say this leads patients to enroll in Medicare, which of course presents a lower reimbursement rate than private insurance does. And so what we've seen in the last 4 to 5 years is a number of cases sort of percolating at the lower court level and the Sixth Circuit Court of Appeals and the Ninth Circuit Court of Appeals. And each of these cases had kind of a singular thread. They're slightly different in terms of procedural issues. Basically, you had a couple of cases, right, where there was, I think in the Ninth Circuit, you had a condition, they said that a conditional payment being made by Medicare is not required before a provider is allowed to sue. And then you had the Sixth Circuit take a different stance there, saying that before a provider, in this case a dialysis provider, has a standing to sue a plan over this language, they require a conditional payment by Medicare. So you had a circuit split there on that issue. And then I think more importantly, you had a circuit split on this other more substantive issue, which is about, the actual impact of the plan language here. And what's interesting here in one of these cases, the Amy's Kitchen case in particular, the Ninth Circuit there rejected what is being called the disparate impact theory, which essentially is saying that even if you have plan language that doesn't single out ESRD patients, even if it's treating all reimbursement the same for dialysis patients, nevertheless, there is a disparate impact, according to the dialysis providers here, on these ESRD patients. So the Ninth Circuit in that case rejected that theory, and you had an alternate case in the Sixth Circuit, this is the Marietta case, which embraced the disparate impact theory. So you have a circuit split there. And maybe, Andrew, if you can drill down a bit more on some like the plan language or what exactly the language was intended to do and why providers are quibbling about, the impact here. So what exactly did the language sort of say in these cases?
Yeah, so first off, one of the main things that the Secondary Payer Act does in regard to dialysis claims is that, in regard to group health plans and how they handle dialysis claims, is that it prohibits a health plan from differentiating based on a person's diagnosis for with ESRD, their eligibility for Medicare. So plans often take the position that any sort of limitation on dialysis as a service is fine so long as it doesn't make any sort of differentiation based on ESRD. So I think pretty much anyone would agree that a plan exclusion for any claims incurred for dialysis from a person with ESRD or claims for treatment of ESRD, that wouldn't be okay. That would violate the Secondary Payer Act. But what we're dealing with in a lot of these court cases is language that applies more broadly to dialysis treatment in general. So a plan might say all dialysis treatment is payable at 150% of Medicare, 175% of Medicare, whatever metric they want to set, period. And the plan doesn't care what the reason for the need for the dialysis is. It could, of course, be ESRD. It could be, some sort of traumatic accident and someone needs dialysis for a short period of time or due to some other illness. To that, the providers argue that the vast majority of dialysis claims are ESRD claims, and that a limitation like that, although, broadly worded, in essence, in effect, is really discriminating against ESRD. And that's sort of that disparate impact theory in a nutshell, and one of the two main issues here. Like Brady said, that's kind of the more substantive issue that's going to relate to whether or not a plan limitation actually violates the Secondary Payer Act. And then the other issue is more procedural, that there's also a circuit split on between the Sixth and the Ninth regarding when a party actually has standing to file a claim to allege a violation of the Secondary Payer Act. So under that issue, whether Medicare has made a payment or not as a result of whatever action it is that is in question, is that going to be a condition, required for somebody to bring a claim without any investigation at all into whether the actual limitation is permissible or not. So those are the two main issues. We don't know, for sure which, or, it could be both, it could be one or the other, which issue the Supreme Court actually, makes a finding on. But, it'll be exciting to see. And it is that Sixth Circuit case, Marietta, that is now awaiting review at the Supreme Court level.
Right. And I looked at the brief that was filed by, I believe it was DaVita in this particular case earlier this month. To your point, Andrew, they're basically saying that, even though ESRD patients are not the only ones who use dialysis, and there's not this explicit language, which would be discriminatory, right? They're saying that the impact nevertheless is still being felt. I think what's interesting here is, typically circuit splits are a ripe situation for the Supreme Court to step in. But I think in this case, there's many of them that don't get Supreme Court review. But I think in the case of dialysis in particular, you're talking about expensive claims, some of the most expensive claims that we see in the industry. And it's a really important procedure, obviously, for patients who require it for survival, right? So I think that partly plays into why the court is stepping in here. And probably because you have these two different issues, right? You have the standing issue, and then you have this more substantive, the merit to the case People are asking us all the time, what do we think is going to happen here? To sort of predict things, and we're not really in the prediction business. However, I think it's safe to say, in my view at least, that I think the court will get past this procedural issue on standing and actually proceed to the merits, partly because one of the cases you already had a conditional payment that was made. And I believe the other case where the circuit said that a conditional payment is not required, I think there actually was a conditional payment already made anyway. So I think this case would eventually get back up to the Supreme Court anyway, even if they didn't reach the issues. I think they're going to find a way to do that here. I could be wrong. Typically, they don't do that, but it just seems like it would be a circular kind of waste of time if they just punted this back down and waited for a conditional payment to be made when there already is one case in which that already happened. But I think one thing to watch here will be if the court does sort of go the way of what these providers are suggesting and adopt this disparate impact theory. I would be shocked because it would have a number of ramifications in other areas of the law with respect to not just the MSP, but other, federal laws like HIPAA, for example, which do have a discrimination component to them. And typically these kinds of laws are written on purpose to, if they intend to include a disparate impact analysis, they will, right? And there are things like civil rights laws, which do or have been interpreted by courts to include this sort of built-in protection that extends the protection, more generally. But I would be shocked in this case if they did that with respect to MSP. I could be wrong, but like I said, it would have a lot more impact, I think, in other areas of the law that I think go far beyond this.
I actually thought about how that would connect to those HIPAA rules as well, being kind of our resident HIPAA nerd. Specifically thinking about the situations that HIPAA outlines where you're able to differentiate based on bona fide employment-based classifications, right? Mm-hmm. So even with those exceptions, the code is clear that these differentiations can't be based on a health factor. So, if we saw this, acceptance of the disparate impact theory, would that mean that now, a differentiation in something like contribution amounts or waiting periods based on something that is a bona fide employment-based classification, like office location, something like that? Are we now going to have to look at the actual impact that has on different groups based on health factors and do almost like the highly compensated individual, non-discrimination testing to see if it has an impact on this group based on a health factor, regardless of being facially neutral? That could get very, very messy.
Yeah, absolutely. And that's something, frankly, we could probably have a whole other podcast about. But that's why, like I said, I'd be shocked if they didn't, sort of come down the other way on this one and not embrace that theory. But we'll have to wait and see. As of now, I just looked again, and I don't see that the court has yet scheduled oral argument. But when they do, you'll be sure to know that we'll listen. I'm not sure they're still doing the video conferences, but if they are, we'll watch. But we'll definitely find a way to hear those arguments when they are scheduled, when they take place. And typically you can learn some things from the oral argument, but maybe sometimes the justices will tip their hand, not usually, but we'll be looking out for that as always. But I think that's all the time we have for today. Hopefully this was a nice little addition to our podcast suite so far, a break from NSA and COVID related things. And we'll be paying attention to this important issue as developments occur. And if you have any questions in the meantime, reach out to us. But for now, on behalf of myself, Andrew Silverio, and our amazing producer, today it's Matt Painton, I want to thank you all for listening in to the Empowering Plans podcast, and stay tuned for another one. Thanks, guys.